contractors and subcontractors, and we have the visitors and members of public. When we are talking about those who will be covered, this is the people who are covered by OSHA 2007 and not by WIBA or WIBA plus covers. Those are two different things, because if you can have, for example, contractors and subcontractors, you as an employer, you are covered by that WIBA, but your contractors and subcontractors are not covered by WIBA. So if you have subcontractors, as we are going to see, and you have them on site or in your workplaces, you are supposed to make sure that they are also WIBA compliant. So OSHA applies to almost every workplace in Kenya, including offices, factories, construction sites, and hospitals. I want us to start with the employer duties. As we said, under OSHA 2007 primarily is protecting the employee, but at the end of the day, even that employee has their own duties or responsibilities when it comes to their own safety. So we are going to start with the employer duties, what they are supposed to do to make sure that their employee is compliant with OSHA 2007. Number one is ensuring that. Sorry about that. So number one is providing a safe workplace. And when we are talking about a safe workplace, is a workplace with no hazards. As we said, that a hazard is something that has a potential to cause harm. So you as the employer have a duty to make sure that the workplace is free from hazards. And if we have hazards, that those hazards are well managed. Secondly, providing safe equipment, through maintenance of equipment and machinery, regular inspection and maintenance. Number three, as an employer, you're also supposed to make sure that you conduct risk assessments, that you are able to identify and inform your employee of any potential hazards. You review and you make sure that you review those hazards periodically. You're also supposed to implement appropriate control measures, as I said. So even if you'll have a workplace where we have potential hazards, you are mandated to make sure that you're able to manage those hazards. And how to do that is ensuring that that your employees are aware, your employees are trained, and your employees have any required PPEs to manage those hazards. In terms of personal protective equipment, it is the duty of the employer again to make sure that the employee has all necessary PPE requirements, from safety helmets, gloves, safety boots, all that, and to make sure that number one, that the employee is aware of the reason why they need the PPEs, not just providing a helmet and you're not informing your employee of the reason they have the PPE and how to use the PPE. I also mentioned training. So training should be something that is continuous for high risk workplaces, making sure that you have toolboxes every morning to make sure that you are going through the hazards that are expected to come up during the day, or the hazards that are potentially already there in the workplace, and ensuring that your employees are well trained to manage those hazards. Something which is very important and usually escapes many employers is emergency preparedness. I always ask, if you are an employee, if your employer has told you of what is expected of you, if, for example, there is fire. In most cases, you'll find out that many people are not aware of emergency or fire exits in their own workplaces, or even as something as simple as use of fire fighting equipment. So during the audits, the auditor, for example, if you have a fire audit, you'll find that most employers will make sure that we have firefighting equipment, the fire extinguishers. But if we went deeper and asked the employees in that workplace if they know um, how to use the firefighting equipment, most of them might not be able to know. And if they know, they will not be able to differentiate the different types of fire extinguishers. So this is something that you are supposed to do, and not just doing them when you have the audits or when you are just looking to tick off a compliance duty. This is something that needs to be done periodically, and especially when you have new employees. As somebody is coming into your company, make sure you are doing induction trainings just to make sure that they are well prepared in case of an emergency. Others include first aid. You're supposed to provide a first aid kit in every workplace, whether we have high risk or low risk potential workplace. Reporting, we are going to talk about reporting in compliance. And lastly, welfare facilities in terms of clean washrooms, clean drinking water, rest areas, lighting, and
So much
good
for preparedness.
ventilation. I want to jump
WIBA club.
to the duties of our
I care about my
employees.
tasks. I ask, I inquire.
Now, as I said, OSHA 2007 primarily is supposed to protect a Kenyan worker
Is it
or a Kenyan
documentation?
employee, ensuring that their occupational safety and health is maintained. And that duty usually falls to the employer. At the same time, it highlights um, an example of what can happen if, for example, you as the employer have provided all these compliances, you have done everything that you should be doing in terms of the act, but the employee is not following up. So number one is the duty of the employee to take personal responsibility of all rules and regulations under the Occupational Safety and Health Act of 2007. This is done by observing workplace rules, following safe work instructions, and correct use of equipment. Secondly, is the use of PPEs. As I said,
Hello.
that it's the duty of the
Remember,
employer to provide the PPE, to
how
train
much?
the employee on the use of the PPE and why we need to use the PPE. But lastly, it's the duty of the employee to make sure that they wear the PPE, they maintain the PPE, report
I'm not
damaged
talking
PPE,
at the
and
moment.
support workplace safety initiatives. So as we are going to see, in some cases, when we are talking about WIBA, we have areas at which WIBA will not cover. And one area is willful misconduct, that somebody did something against the rules of the company, and they have had sufficient training
How
to
much have they
prevent that
taken?
from happening. So we are going to look at that
Hmm?
under WIBA. Another duty is reporting hazards and
A lie.
incidents. It's the duty of the employee to immediately report unsafe conditions, near misses, injuries, and unsafe behaviors. I think we already know about unsafe conditions. For example, any
You
fire
read from the
hazard
blue
that you can
process.
see, maybe a leaking gas cylinder. Near misses, what we mean by near miss is something that will cause potential harm in the future. So, for example, if you
How would a
see a
game
naked wire,
be free
but
for 100 and
at
then you
that
get
point has
attacked?
not caused electrocution to anyone, that is a near miss. And if you injured at the workplace, it's your
So
duty to
hapo
make sure that
nakwambiaje?
you report that injury to your employee. And finally, unsafe behaviors. This is something I think we talked about in psychological safety. Unsafe behaviors,
Oh,
for example, if you have an incident, it's not going
kwani
reported.
yani,
That is a very unsafe
but wait,
behavior. And
kwani
lastly,
how
is
does
to
it
cooperate and support safety. We are going to talk
meeting
about
like
safety
what?
committees. So safety committees are usually
Mm.
constructed uh,
So the
primarily
game, the moment
using the
slowly download the
employees.
game hivi okay,
The
nipitisha.
people who will be onboarded in the safety committees will be the employees, and definitely the responsibility of the employee to make sure that they're able to participate in, say, safety committees, participate in safety trainings, cooperate during inspection and investigation, and obviously support workplace safety initiatives. So before I go to the mandatory compliance, mandatory workplace safety compliances, any question on OSHA 2007? Any question?
Aye, tough.
Yes, please. You can go ahead. Go ahead, Jobins.
Okay, I want you to go back to the explanation of Unsafe Act. I didn't get very well. I don't know whether I got it right or wrong, because you said unsafe condition, unsafe act, and the near miss.
So very good question. So we have, I think the confusion is between an unsafe condition and an unsafe behavior. Is that your question?
Go to an Apple store.
Unsafe condition, a near miss, and an unsafe behavior.
Yes, unsafe act, unsafe condition, and near miss.
Good. So we can start with a scenario. So for example, if you have a workplace kitchen and you find that we have a leaking gas cylinder, that is an unsafe condition, because that kindly
life is
can mute.
uncertain.
Okay, thank you. Because if somebody ignites
Life is uncertain, bro.
anything near that leaking gas cylinder, there is a potential to cause. There is a potential that you are going to have fire. So that is an unsafe condition. A near miss means we have a potential for injury, and I give an example of a naked wire. I can also give an example using the same gas cylinder. So we know that a gas cylinder is a hazard in its own, but at the end of the day, we must have it. So how do we manage the gas cylinder being in an enclosed area? You can have the regulator taps that you can cut off the gas. If, for example, the burner is unable to regulate, you can turn off the gas cylinder using that tap, and so you will not have any leaking gas. Or you can make sure that the gas is stored outside. So if you go to maybe the supermarkets, you're going to see that the gas cylinders are stored outside. So a near miss basically means that you have identified an unsafe condition. There is no immediate danger that it's going to cause harm at that particular time, but in the future, there's a possibility that it's going to cause danger. And finally, an unsafe behavior is, for example, as I give an example of you have seen that leaking gas, or somebody identified a leaking gas and they did not report. So that is a behavior that will cause maybe a more serious incident in the future. So the three are the responsibilities. It's the responsibility of the employee to report unsafe conditions. If you see something that is going to cause immediate danger or immediate incident, you're supposed to report. Something that is not going to cause immediate risk or incident, but there is a possibility that in the future it's going to cause that, you are supposed to report that. And finally, any behavior that you deem is not appropriate to ensuring that we have a safe working environment, you're also supposed to report that. I hope that is a bit more clear.
Okay, you can proceed.
Right. So I want to look at the mandatory workplace safety compliances. So number one, which is mandatory, I think the registration of a workplace to DOSH. That is the first one. Secondly is safety induction, making sure that your employees are provided with safety induction, especially the new employees, and then going training in workplace hazards, emergency procedures, and safe workplace practices. Another mandatory compliance is ensuring that you have emergency preparedness. As I said, for example, the fire drills, the first aid drills, etc. Another mandatory compliance is ensuring that your incident reporting is done within the stipulated time. We said for fatal or serious within 24 hours, non-fatal within 7 days. You also mandated to make sure that you are keeping all the safety records. Well, what we mean by safety records are workplace registration certificates, risk assessments, audit reports, safety committee minutes, PPE logs, etc. And lastly is ensuring that your employee is provided with good welfare facilities. These are the washrooms and the cleaning and clean drinking water. Another very important compliance is WIBA. And we have, so WIBA is the Work Injury Benefit Act of 2007, which is a mandatory legal requirement in Kenya. It requires employers to compensate employees who are from occupational diseases or death arising out of and in course of employment. The purpose is to protect the employee against financial losses due to workplace injuries, ensure employers meet their legal obligation, and obviously compensation is administered in accordance with the DOSH processes. So WIBA is mandatory. What is not mandatory is WIBA Plus, and which is always an example. So WIBA Plus is basically an enhanced insurance product from the insurance companies, which is maybe a top up from WIBA Plus. So a very good example of how WIBA is different from WIBA Plus. So let us take a scenario, and I want maybe the employers will tell us from this scenario what is supposed to happen. If one of your employees is involved in an accident when going home, will that employee be covered by WIBA? Maybe somebody can tell us. Let us all get involved kindly. You have an employee who was involved in an accident while when going or coming to work. Is it covered under WIBA? See, somebody said no. So the simple answer is no, but there is conditions to it. So if this employee was involved in an accident while using public transport, definitely if and you have only WIBA as the basic WIBA insurance cover, then they will not be covered by the insurance cover. But if they were traveling using a company provided transport, maybe a bus, a car, a motorcycle, then definitely they'll be covered under WIBA. Now, if you have WIBA Plus covers such scenarios because it covers the employee for 24 hours before or after they exit the workplace. So in this scenario, the simple answer will be always no, unless they were traveling using the company provided transport, or if the company has WIBA Plus. So I think that is one very common example of the difference between WIBA Plus and basic WIBA, which is mandatory. So WIBA is not required by law, but many employers purchase it to provide a broader protection and reduce financial risk. It's also good to note that the premiums, the compensation you're going to get from WIBA Plus will be a bit higher. So also make sure that your employees are better covered by the insurance cover. Now, I want us to look at the consequences for non-compliance. But I'm sure people will have questions about WIBA. Maybe a question about WIBA. Questions about WIBA? Anyone? All right. So let us look at the consequences of non-compliance. What is going to happen if you're not compliant with OSHA Act 2007? So we have legal consequences. The most common one is improvement notice that once a DOSH personnel visits your workplace and there is failure to comply with OSHA, the following is going to happen. Number one is improvement notice, which is correct, identify safety deficiencies within a specified period. Prohibition notices that you're told to stop the unsafe work or processes that may cause imminent risk. If you're not able you're not able to comply with the first two, there's always a potential for prosecution, and you'll be prosecuted using the OSHA Act of 2007. Or at the end of the day, if you are found guilty, you may face fines and imprisonment. We have the financial consequences. We know that the moment, for example, you are fined, obviously goes to your bottom line, which is the finances. We have the personnel costs, medical expenses for an injured person, and compensation claims for WIBA. We have loss of production during investigation of closure. And obviously, the moment you are found to be high risk, to be a company or a workplace that is high risk, there is always potential that the WIBA provider is going to increase the insurance premiums. One thing that may never, you are able to pay the fines, you are able to pay the premiums, but one thing that is going to stick with you is the reputation. Not many people will want to work in an environment where there is always a potential that you're going to get harmed. So you are not able to attract the best talents or investors or clients or donors or even the general public. Because if, for example, they know that somebody died in a specific construction site, many people will not be comfortable visiting. Maybe you have a customer will not be comfortable visiting, or you have an employee who will maybe shy away from such a construction site. A poor safety performance can damage an organization's reputation, which again, as you said, is going to reduce the public trust and obviously is going to affect the financial capabilities of that company. You don't want to be paying every now and then those compensations. And you already have maybe different people who have been injured at the same time. So you have to replace those people because at the end of the day, they will be coming to work. So making sure that you are compliant will prevent you from the legal consequences, the financial consequences, and obviously the reputational damage that may come with the non-compliance. There's something I wanted to highlight, that there's no financial penalty that can fully compensate for a loss of life or a long-term disability caused by preventable workplace accidents. It's, as I said, that is something that is going to stick with you. If, for example, you are HR and you're in a company that somebody lost their life. Even if you leave that company, that is something that is always going to stick with you. So you don't want to change or to alter the shape of a family over something that maybe you could have prevented. Something as simple as a PPE, ensuring that you're able to provide a PPE that is tomorrow going to prevent a serious incident. So make sure as an employer, you are able to make sure that your workplace is compliant, just to make sure that at the end of the day, you do not cause any irreversible damage to a person or to a family. Most importantly, when it comes to compliance, is how we can ensure that we are able to maintain that compliance. So number one, as I said, is registration of a workplace. We looked at what comprises of a workplace from this. What comprises of a workplace? We said an office, factories, construction sites, and hospitals. So if you have any of those, you are supposed to make sure that you are registered as a workplace under DOSH. The registration is usually 5,000, a registration fee of 2,000, and a levy of 3,000. Before you do the registration, you are supposed to get Samuel. Samuel, kindly mute. Thank you. So you're supposed to do two things. One
Okay.
is conduct the safety audit and the fire safety audit. And what you're supposed to get is the auditor's number to make sure, because that is what you're going to use to when you are registering. Um, you need to register again the number of employees that you have. And if you have more than 20 employees, you have to form a safety committee and ensure that you are keeping minutes. And this also comes up when you are doing any renewal. Again, during renewal, the cost will be 5,000, 2,000 for the renewal, and 3,000 for the occupational safety and health levy. When you are renewing again, what should be asked is the number of your auditor, the safety and health auditor, and the fire safety auditor. So you have to make sure that those two have been conducted, and you have the registration number of the auditors. You also going to, during renewal, you're going to indicate the number of employees that you have. And so as if you have more than 20 employees, you have to make sure that you have already formed a safety committee and you have the minutes from the safety committee. Um, Now, on the safety committee, I always get questions on what the work of the safety committee is. So basically, the safety committee is comprised of the management, but primarily the workers from different departments. And you sit down and you discuss everything to do with safety in the workplace, from any hazards that may have been identified and have not been managed, to all the different things to do with occupational health and safety in that specific workplace. The work of the safety committee is just ensuring that the workers have a platform in which they can express maybe the unsafe behaviors, the unsafe conditions, and ensuring that at the end of the day, the management is able to hear from the employees directly. Something else that falls under compliance is protection of the workers. As I said, that ensuring that every year you're able to buy the WIBA insurance cover, whether you're going to buy the basic or the WIBA plus, ensuring that you have a first aid kit, which is mandatory, as we said, that is a mandatory requirement. The moment you have a safety and health auditor, one of the things they are going to look at is this fire first aid kit, while when you're having the fire auditor, he's going to look at the fire fighting equipment. Something else which is mandatory is provision of ensuring that we are giving our employees PPEs, and it's the correct PPEs, and ensuring that we train them and we train them on the use and the need for the PPEs. I want to now talk at this juncture talk about reporting. It's just a moment. I want to talk about the reporting of incidents because it's something that always comes up. We said that if it's a serious incident, it should be done within the first 24 hours. If it's not a serious incident, it will be done within the first 7 days. Immediately after the incident, you are supposed to take the incident reports, witness reports, and these are the documents that you are going to provide to DOSH for as your submission. So after submission, DOSH, what they are going to look at is one, was there any willful uh, 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 wrongdoing in terms of was the employee, number one, was the employee provided with all necessary PPEs, and if yes, was it out of for example, a very good example is if the employee was drunk. And um, just to highlight, maybe ask, which is also a very common question, what happens if, because a very common question, if you have an employee who came to work drunk and they got injured? Anyone? You have an employee who came to work injured and they got into an accident at work. What happens? Anyone? Somebody can try and answer that. You obviously know that that is not supposed to have. You're not supposed to
Type of
have
shit I do.
an employee who's working drunk. But if that happens, what is
You know,
supposed to happen?
cooler. And the type of shit I do.
Anyone?
Sorry, not the office.
You can raise your hand or unmute.
No, I can do that shit.
To me, I feel that is negligence, so there should be no compensation.
I got the skill.
When I get training, smoke, okay.
Yes, Robert.
Oh, can you get me?
Yes, I can.
By the book.
Okay, maybe a drunk employee, first of all, should be subjected to counseling. It may result from maybe some psychological issues. Then thereafter, if the issue persists, then we can maybe declare the employee unfit after due process by the HR.
Okay. Anybody else? Anybody else with an opinion?
Hello.
So yes, yes, Sarah.
I feel that even if they come to work drunk and then they get into an accident, then maybe you have to prove that they were actually drunk. But if you can't prove, you will be in the wrong to not compensate. You can't call it negligence without evidence. Thank you.
Okay. Anybody else? Anybody else?
I think the employee must be compensated because you do not have proof. As much as you know that he's drunk, you'll not have proof because you have to subject the employee to a test to ascertain the level of alcohol content, and that will take a longer period because if the employee decides to go legal, the organization is at fault. So do due diligence, compensate the employee, and let the law take its course.
Okay, thank you, Winnie.
Even just like me.
So we are going to use that incident. We are going to use that as our case study. We have a drunk employee who came into work, and while they were operating a machine, maybe they got injured, and they lost a finger. So, so in this case, we know that they lost a finger. That is the incident. So the moment you as the employer or the supervisor is informed, number one, you're supposed to provide first aid. And this goes back to what we talked about in compliance, ensuring that we have a first aid kit in the workplace. Because every compliant workplace must have a first aid kit. And you cannot have a kit without people who are trained in first aid. So, which brings us to ensuring that even if it's not mandated to do the first aid training, making sure that you don't just have a kit, but you also have people who can actually use that kit. So, you're supposed to provide the training, the first aid. After providing the first aid, you will take this individual to hospital. So in parts, as you provide the first aid, you will try to establish what happened. And so, for example, from the witnesses or people who are there, or you yourself, you're going to feel that this person was drunk during the operation of this machine. So you need to have witnesses who will be able to write down and assign to it that they saw that this employee was drunk. Number two is find out if he or she was trained to use that machine. Again, find out if this person had all the necessary PPEs. So that is the first thing you need to do. As again, you rush this person to hospital. Maybe you can have other people who are establishing the facts about the incident. When you take the individual to hospital, you must get a doctor's report and fill out the DOSH Form 1, which is basically a notice by the employer for an accident. The medical assessments, by a qualified personnel will also be submitted as part of that form. You're also going to send a copy of the reports to your WIBA insurance provider, so that they can open a claim file. So once it gets to DOSH, DOSH will determine two things. Number one, the extent of the injury. We talked about permanent disability, or in this case, we don't have fertility, so it's permanent disability that will affect the livelihood of that person. At this point, we said it's a finger. So depending on the work that they were doing, if they will still be able to continue doing the work that they have been doing without that finger, then falls on one side. But if they cannot continue doing the work they have been doing normally, which means they not be able to make a living, then that is another different category altogether. Now, secondly, we are going to come back to that. Secondly, we said about willful negligence. Now, willful negligence only goes to the extent if it's a minor injury. So if it's a minor injury, there will be no compensation for this individual. But if we have a serious injury causing permanent disability or fertility, then this person will be compensated. And that is what I meant when I said that those will be trying to determine if the lost finger will affect the ability of this employee to make a living. So if the answer is no, then it falls under willful negligence, and this person will not be compensated. But if the answer is yes, that the lost finger was what was operating the machine, and the only thing this person can do for work is operation of that machine, and he or she cannot operate this machine again because they have lost the finger, despite them being drunk, it becomes a permanent disability, which is causing a permanent which is causing the causing the ability to make a living. So what the law provides is that you can punish this employee, but you cannot punish their immediate family, because at the end of the day, this employee is unable to provide for himself and for the family. So if they're not able to provide for themselves alone, for example, in a minor injury, then at that point they are not going to get any compensation. But if it affects the ability to provide for their family, then there will be compensation under those conditions. So after the medical assessments and those have established if it's permanent, permanent disability or minor injury, we obviously move. So for in this case, our worker is not able to operate the machine again. Then the DOSH evaluation and award certificate is given. A DOSH officer will inspect this, will come to the site and verify that the worker will not be able to operate that machine again, and issue a computation or compensation certificate. And finally, once that is issued, the insurer will pay the assessed medical bills and disability compensation to the employee. Once paid, DOSH issues a WIBA payment certificate, and the file is officially closed. So in this case, you are going to the employee will be paid compensation for the disability and any financial any financial or medical uh, uh, financial or medical capabilities that were provided by the employer during the investigation of the incident. So to answer to answer everyone, if this employee came in drunk and was injured and they caused permanent injury, they'll obviously be compensated. But if it was a minor injury, they will not be compensated. But at the end of the day, there's something that when DOSH will come to do the investigation, we look at. Number one, have you put a mechanism to make sure that you're able to get those who are drunk? For example, an alcohol detection machine, a blowing machine at the gate, or you have made sure that your employees are aware of your policies to do with coming to work drunk. So when you are drafting maybe your policies, your contracts, it's good to make sure that your employees are aware of your company policies when it comes to coming into work drunk. I hope that answers all the questions about willful negligence. So just because somebody was doing something against the company policies, and you have provided every possible management for the hazards, but they still went ahead and did their own thing, doesn't mean that they are not going to be compensated. So if it's permanent or a permanent disability or a fertility, they will obviously be compensated. But if it's a minor injury, there will be no compensation. So I want to open the forum to anyone who may have a question. Anyone who may have a question? Yes, Sarah?
Hello.
Yes.
Thank you very much for sharing that very important information. My question is, what type of injuries are we supposed to notify to DOSH? Like, let's say an employee steps on a nail and
Yes.
injures his foot. Are we
Yes.
supposed to notify that?
So yes, any incident or injury in a workplace, you are supposed to inform DOSH of the same, whether it should be a minor injury or a major injury. At the end of the day, that person is going to go to a hospital. and you are going to pay bills for that person will not be coming to work, so you are going to make a claim for the same. So you have to report to DOSH so that they are able to place any to provide any certification for the same.
Thank you.
Any other question?
Mr. Faris,
Yes.
like in a scenario where, let's say a staff has gotten injured
Yes.
and refused to be subjected into an alcohol blow test or so. So what really happened?
So that is one of the scenarios in which somebody is not compensated. If you refuse to get a medical report, then obviously you are not going to get any compensation. So there must be a medical report. So if somebody says no to the medical report, then there will be no compensation. But then the day you still have to report the same to DOSH that this person there was an injury. Uh, you do your investigation and report the same to DOSH, indicating that this person refused to get medical attention. Yes, Robert?
Hello, can you get me?
Yes, I can.
I have a hypothetical question.
Yes, go ahead.
An employee is entrusted with a machine, a moving machine, for instance. The moving machine does not have anything indicating when it should next be serviced or when it was last serviced, and thereafter it causes an accident, and the employee has been blamed for the same.
Okay.
How does an employee ensure that we avoid such scenarios?
So we'll take it into number one, what happens after the incident and how the employee can how the employee themselves can avoid that. So we can start on how the employee could avoid that. We said that it's the duty of the employee in this case to report any unsafe condition. So if they saw that the maybe the machine was not working as stipulated, it's their responsibility to report that unsafe condition. Now, in most cases, you'll find in such cases, before it even crashes, several other incidents have happened. And those are what we are calling the near misses. So maybe before they even crash, something else has already happened. Maybe this machine has tried to injure them in the past, and that did not happen. So they're also supposed to make sure that they report that. Now, after the incident, what the employer is trying to do is prove willful negligence, basically trying to blame the employee for the accident. So, as we are talking about investigation, part of the investigation is witness statements. And one of the witnesses will be the people who have been operating the machine, and if the operator is in a condition to give a statement, they will give a statement indicating that they have had the machine working in an unsafe way. Now the question is, did they report? Whether they reported or not, it will be very hard for you to prove willful negligence in a case where the witnesses are claiming that the machine was not being serviced or was not working as stipulated. So in this case, they'll still get compensation, but we will go back to the consequences of non-compliance, because one of the mandatory things for you to do as an employer is making sure that you are providing your employee with machinery and equipment that are in good condition. So at this point, you're already non-compliant, and all the legal consequences will come in play. So you can get fines. You can be told to make sure that the machinery is serviced within the aspirated timeline, and or at the end of the day, you can be fined or even jailed due to your negligence. So the employee will be compensated, and it will be very hard for you to prove willful negligence. When you're proving willful negligence, for example, of that of maybe the employee, you have provided training to the employee on use of the machinery, you have provided any PPE necessary to operate that machinery, you have identified and trained the employee on the potential hazards that may occur when operating this machinery, and you have serviced the machinery. And what happened, the incident arises from the employee doing something with the machinery that is outside, maybe outside what they are supposed to do. They were using the machinery to do the wrong thing. Then at that point, you can be able to prove willful negligence. So if you are able to prove willful negligence, if it's a minor injury, they'll not be compensated. But if it's a permanent or fatality, sorry, they'll still be compensated. So there's a question in the chat box. In the event where witnesses decline to provide a statement following an incident or such as a fatality, maybe out of fear or otherwise, how do you handle such a situation? That's a very good question. But what maybe we can talk about before that is the psychological safety. We always say that it's the duty of the employee to provide a platform in which your employees are able to, one, report incidents, and if reports an incident has occurred, they'll be able to provide witness statements comfortably without fear of intimidation. But now, if that has already happened, it means you as an employer has already failed. So what is going to happen? So what DOSH does is they will try to get alternative witnesses, and they will maybe provide witness protection to the alternative witnesses just to get a picture of what has happened. In most cases, DOSH will not be able to do that. So there's personnel. If it's due to there's a fatal incident, the family or the people immediate to this person can go the legal way or the court way. So if they go through the court way, you might be forced by the court to present evidence. You can be called by the court to present evidence under instruction of the court. So in this case, it's not DOSH who will be doing the investigation. The investigation will be done using the legal or court system. And at the end of the day, if you are called by a court as a witness, there's not much you can do. But you will be forced to provide the evidence. Another question? Another question? Another question? So, and just to mention, for those they don't rely on the witness statements. They will also rely on alternative evidences. We can have CCTVs, all that, maybe a CCTV footage. So they just don't rely on the witness statements. Sometimes even the witness statement can be misleading. So they just don't rely on the witness statements. They'll also try to gather their evidence using other ways.
Faris, now you touch on the CCTV footage.
Yes.
Are they admissible in a court of law when they are adduced as evidence?
So the answer is yes, but how the CCTV footage was provided might be the only problem. So for the CCTV footage, there has to be a procedure of retaining the footage. So that is from the storage, making sure that you have the original footage from the storage system. Uh, the only problem comes in if the footage is obtained through uh, illegal means. Maybe you stole that CCTV footage, then in that case it will not be admissible in a court of law. Any other question? So if there is no other question, I want to.
Hey,
Yes.
I have a question.
Yes.
There is this incident reporting book that we normally capture each and every incident, maybe minor injuries that we normally have maybe at the reception or in the HR office.
Yes.
Does that also qualify maybe to be taken to the DOSH office, or when you report to that book, must you report it to the DOSH office also?
So what we said, what you report to the DOSH office is in case of injury, minor, major, or fatality. What is recorded in the incident book are the unsafe conditions, the near misses, and including any injury report. So the answer is you are not going to present that to the DOSH office if it's a near miss or an unsafe condition. But when the DOSH comes to investigate an incident, if you are reported maybe a major or a minor injury, one of the things they are going to look at are the incident reporting books, the witness statements, etc. So it's only going to come into place when you have a major incident, but also forms part of the safety reporting documentation, that incident reporting book. Can WIBA intervene on behalf of an employer in case that the third party, say the insurance company, refuses to pay the employee? So the moment uh, okay, I think just a small confusion. So WIBA is provided by an insurance company. The insurance the compensation will only be provided once DOSH, which is the government agency, provides the compensation certificate, basically telling the insurance company that they have done the investigation and this individual needs to be compensated. So once DOSH provides that compensation certificate, it's you to follow up with your WIBA provider to make sure that you get the compensation. In some cases, the insurance company will conduct its own investigation, and if they come to a different conclusion, then the only way to solve that is through a court of law. So at that point, you have already moved on from DOSH. So when you're going to court, you are going to go with the DOSH reports, your own reports, your statement reports, your doctor reports, and the WIBA provider, the insurance company, will come with their own report, and then the legal process will be undertaken, and the final judgment will be made depending on how the the judge or magistrate sees the case.
Will I be right to say or wrong to say that Dosh goes to court on behalf of the person? And additionally, now I want now to give my question. I have I have a case, similar case, which an employee got injured and the Dosh awarded 5%. I mean, we went to our Dosh approved doctor who approved 5% incapacity, and we took it to Dosh. They did the calculation. WIBA 4 was sent to the insurer, but insurer declined. They said like we don't agree with this, so they shared that form. I think it is Dosh form 12 of something of that sort. And then they requested Dosh to to send the employee to another doctor, their Dosh doctor, to review that, which was done. So in that case, now my question is, can still the employee now was awarded from 5%, now he was awarded 2%. In that case, can the insurance still refuse to pay that? And it is coming from the Dosh, who is supposed to stand on behalf of the employee, maybe in court. Thank you.
So I think there is a classic case of the WIBA insurer refusing to pay. They have two things they can do. One is send you back to another doctor to see another doctor, just to confirm that the first report was maybe genuine, and in some cases, the second doctor maybe is going to say that this employee was not injured as they claimed, or the second doctor will say that the employee was injured as they claimed. So the moment DOSH provides the compensation certificate, it's the duty of the WIBA insurer to provider to pay. So if the legal duress is to make sure that the legal process is to, if they are not comfortable with that, they can seek a second opinion, or they can move to court. They can move to court to stop that process. But in most cases, what they will do is refuse to pay, and it's you, the employer, now to follow up, because at the end of the day, you're the one who have incurred the financial obligations. You have the person who have taken this person to court, to hospital. You have the person who have been paying the salary to a person maybe who has not been coming to work. So it's for you now to follow up through the court process, and it's the court that is going to determine now between the DOSH approved doctor's reports and the DOSH compensation certification, and the claim of the insurer on who is in the wrong and who is in the right, and if those payments needs to be processed. What was your first scenario? First question. Remind me.
Okay, my first question was more of a feeling like this case, the Dosh is now the one who is supposed to go to court.
Yeah. So Dosh will go to court on behalf of the employee if, number one, the employer was not compliant, which means there's no WIBA insurance cover. That is the first one. So they will be seeking compensation from the employee directly. Or secondly, as a witness in a case where the employer had a insurance cover, a WIBA insurance cover, and there is a dispute between what was provided by the WIBA, by the DOSH process, and what the insurance provider is claiming. So in this case, they will be coming up as a witness on behalf of the employee. So there's a question on the chat board on so an employee injury claim was processed through DOSH HMIS, and a DOSH 4 assessment was issued. However, the employee disputes the disability assessment and the compensation awarded. At the same time, the employer's insurer has declined liability, citing late reporting of the injury and arguing that is no longer responsible for the claim since the business relationship has ended. In such a case, what is the right and obligation of the employee, employer, and the insurer? What would be the appropriate practical way to resolve the dispute? Now, once the compensation certificate is issued, and the insurer has refused to pay. But no, sorry. In this case, it's the employee who is disputing the disability assessment. So they can now start their own process where they will seek from a DOSH approved doctor a second opinion, and of which that medical report will now be taken back to DOSH for reassessment. So if they are the ones who are disputing, they have two ways they can do this. Take their second opinion to DOSH, or start a legal process through the courts to try and get compensation. In this case, most likely, if the reporting was done late, means that the WIBA insurance cover is not going to be held accountable. Is not going to pay. And the reason being, we talked about the reporting period. If it's a minor injury, within the first 7 days. If it's a major injury or fatality, within the first 24 hours. So if the reporting was done outside those timeframes, then definitely the insurance provider has a legal basis to refuse payment. But then that doesn't mean that the compensation of these employees is not going to be done, but it's only going to be done now through the court system, not through the DOSH stroke WIBA dispute resolution process. So they can still go to court, because it's not the responsibility of the employee to do the reporting, but the responsibility of the employer. So if you as the employer reported the incident outside the time frame, you'll now be held liable for the compensation. Maybe just to add to that, if I may go back to this frame, who is covered by OSHA 2007. All these individuals, permanent employees, casual workers, contract staff, interns, contractors and subcontractors, visitors and members of public. All these people are covered by OSHA 2007, but they are not automatically covered by WIBA or by WIBA insurance cover. The people who are covered by your own cover are the permanent employees, casual workers, contract staff, interns. We jump from the interns to visitors and members of public. Contractors and subcontractors, somebody who has come to your facility or your workplace as a worker, subcontractor, a supplier, is not covered by your own WIBA, but they are covered by OSHA 2007, meaning it's your responsibility to make sure that their occupational safety is well taken care of. But in case of an injury, the contractors, subcontractors, suppliers will not be covered by your WIBA cover. They will be covered by the WIBA cover of their original employer. However, and that is why I'm saying that, however, if the WIBA, maybe the insurer, the WIBA provider declines to pay that subcontractor or a supplier or a contractor, they can sue you through a court of law to get compensation because they were injured in your workplace. And it's usually is done if you did not protect them well enough while they were working in your workplace. So it's your responsibility. Always a good practice if you have a supplier who is coming to your workplace, that you provide them with any necessary PPEs. You provide them maybe with an induction, a very small induction. Just tell them, in case of a fire, this is what we do. Make sure we have hazards. These are the hazards. This is how we manage them before they come into your workplace. Because if they are injured, maybe in the process of offloading or offloading some items that they had brought you, then at that point you can also be held liable if you do not provide enough enough occupational health and safety to them while they were working in your workplace. Any other question? So if there are no other questions, I want to hand it back to Miriam. Thank you very much for the engagement, and I hope I have answered the questions asked. If anything is not clear, we can always have another session to make sure that everyone is well provides in terms of occupational health and safety. What I would end with is making sure that everybody understands that safety starts with you. The responsibility of safety is for both the employer and the employees, but under the Occupational Safety and Health Act of 2007, that responsibility primarily falls under the employer. So make sure that everyone who's coming to your workplace goes back home in the best shape possible, both physically and psychologically, and provide all the necessary trainings that may need to be done to that person to make sure that they are aware of their rights and their working conditions and everything around them. So thank you very much for your engagement and have a lovely day. Miriam?
Oh, wow. Thank you so much, Mr. Faris. Thank you so much. But before you leave, I can see a few people asking for the slides and the contact. If you can share your email kindly, if you don't mind, that would be very helpful. I think I saw it at the end of your presentation. Yeah. Yes. He will share the email. It was there during the presentation, so that you can also reach out to him in case you have any questions. But that was really engaging and very helpful and practical as well. Yes, you can continue to clap for him and give him those flowers. He deserves that. That was really nice, Mr. Faris. Thank you so much. So thank you. Yes, thank you for showing him all this love. Yeah, and it's because of what he has done that was very practical. And also thank you to all of you who have joined us today for this webinar, just learning about OSH, our safety, and those of our employees. I don't know how many employers are here, but I hope you've taken the notes that OSHA safety lies entirely on the employer, but also for the employee to know that security also starts with you. And so please let's create a safe workplace for all of us. That is the employers and also for our employees. Thank you so much, Mr. Faris, for that. And so
maybe Miriam, just to correct, safety falls on both the employer and the employee, but the mandatory compliance falls on the employer. The compliance falls on the employer, but the responsibility on maintaining that occupational health and safety falls on both the employer and the employees.
Thank you.
The guys will have to take your notes and do what.
Thank you for
It's gonna be it's just going to be a very
Mwanaisha.
to compare.
Yes,
How
please.
fast?
After
I
me.
need a certificate.
Because of this depend on the
I
section.
need
Because these are the guys like
the
maths,
certificate of
maybe
this
in school,
training.
what seems to you.
Yes, yes.
How can I get it?
I'll share briefly in a few minutes, just a few minutes. So yes, so before we leave, we have two links I have shared in the chat box. Please have a look at them. One link is for our Google review. So we kindly request that you take a minute to share your feedback with us, and this helps us to improve our quality, the quality of our training sessions. So please spare a minute to do that. And the second link that I have shared is for the certificate download for all participants. So if you are here and you would wish to get a certificate, we have one link that will guide you towards that. You'll share your email where that certificate will be shared, and once shared, you can always print and have it for your own good. And so as we conclude, we also invite you to stay connected with us, that is ACCUREX, via our social media in YouTube, LinkedIn, and other social medias via the name ACCUREX Consulting Company. But in simple, you could just search www.accurex and you'll find us there. So also don't forget to be joining us every Wednesday from 11 a.m. to 12:30 p.m. for these wonderful and impactful training webinars. So please take that time and always join us for this. We call it the ACCUREX o'clock. So thank you so much for joining us. And on behalf of ACCUREX Consulting Limited, we thank you for joining us and wish you a very fruitful and wonderful day as we continue to learn more about our workplaces. Thank you. We can live out our own pleasure.